Hi everyone, welcome back. We hope you had an enjoyable break. You are in for a wonderful educational experience with our next speakers, and the focus is on a legislative update protecting vulnerable adults from financial exploitation in the banking and security industries. Our featured speakers include Kelly Lammers, who was appointed by Governor Pete Ricketts as the Director of the Nebraska Department of Banking and Finance on September 8th, 2020. Kelly began his career working as a teller intern during high school, eventually becoming an examiner trainee. During his tenure, he has held positions along the way of senior examiner, review examiner, IT administrator, and deputy director. Lammers is a fourth-generation Nebraskan. He holds a bachelor's degree and master's degree in business administration from the University of Nebraska-Lincoln and is a graduate from the Colorado Graduate School of Banking. Kelly has held advanced certificates in information security and information systems auditing and currently holds the designation Certified Examination Manager. Accompanying Mr. Lammers is Claire McHenry. She is the Deputy Director, Securities Bureau with the Nebraska Department of Banking and Finance. Ms. McHenry has over 15 years of state securities regulation experience and is an active member of the North American Security Administrators Administration Association. She earned her Bachelor of Science in Business Administration from the Washington University in St. Louis and her Juris Doctorate from American University, Washington College of Law. Please join me in welcoming our next speakers.
Thank you for that kind introduction. It is great to be with you this morning. Thank you so much for joining together on this topic of protecting our fellow vulnerable and senior adults. Our segment this morning is titled Protecting Vulnerable Adults from Financial Exploitation in the Banking Securities Industry and is addressing legislation tailored for the banking, credit unions, and securities professionals. The laws presented today will give the financial institution professional that sees financial exploitation of a vulnerable or senior adult the means to step in, to slow the transaction, to make referrals, and to help the victims. Together, we can make a difference. And I am attempting to advance the slide here. One moment, please. Okay.
Just click on the slide and push forward or space bar.
I apologize for that. Thank you
No worries.
very much. As we move into the presentation, please consider our comments today a presentation. This is not a legal interpretation nor an indication of Nebraska policy. People work a lifetime to acquire assets, savings to provide for retirement, and want to feel safe in their retirement, and yet the crime of exploiting vulnerable adults is on the increase. Over 1/3 of the people 60 plus report others calling or others mailing them and asking for money. Only 1 in 5 people over 65 have been a victim of financial fraud, yet only 1 in 23.5 cases are ever reported. While in 2011 the losses associated with elder financial abuse were a troubling $2.9 billion, that number has grown considerably in 4 short years, and over $36.5 billion in 2017 and $37 billion in 2018. While there's a belief that elder financial abuse only happens to those that are not paying attention, or possibly from elders considered less financially aware, the facts point out anyone can be a target. In 2011, Mickey Rooney testified to the Senate Special Committee on Aging regarding his personal experience as a victim of elder abuse. He was unfortunately the victim of financial abuse at the hands of his stepson from his 8th wife. In court documents in his suit against his stepson, Mickey Rooney alleged that his son stole $8.5 million from Mickey, kept him in the dark about his finances, used threatening and abusive language, and refused him basic necessities such as food and medicine. Mickey had to obtain a restraining order against his stepson and was appointed a conservator. Mickey testified before Congress a few weeks later. The stepson ultimately agreed to pay $2.8 million in a civil settlement, and it's reported the stepson has not simply paid that back. When Mickey Rooney passed away at the age of 93, it was reported that he only had $18,000 in his estate. His wife denies these claims, and he continues to receive Mickey's pension and Social Security benefits after he passed away. To help stop this kind of exploitation, we need financial service professionals to step in. Report what you're seeing. There are a number of community and business benefits reporting financial exploitation. Improve safety, preserve depositor and client financial independence, preserve your institution, firm, reputation, and goodwill. Empower your employees to take action. Regular contact with your clients and customers put financial services in a unique position to detect behavioral changes, see unusual transactions, and assist in protecting clients and customers before assets have been distributed. Bottom line, we need financial services to step in and be part of the solution. Claire will shortly walk you through the securities side of the house. However, I want to start with banks and credit unions. Codified as Chapter 8, Article 29, financial exploitation of a vulnerable adult or senior adult is only 3 sections long. 8-2901 provides terms relative to a depositor. 2901 also defines vulnerable adult for a depository, which has the same meaning and cross-references with the securities statute in 28-371. Also, that section defines financial exploitation as the wrongful or unauthorized taking, withholding, appropriation, or use of money, assets, or other property, or the identifying information of a vulnerable adult or senior adult by act of omission, including power of attorney. Previous speaker left just an incredible impression upon me. Power of attorney is not a license to steal. As financial professionals, there's so much we can do with this legislation. The Act continues and indicates that the unlawful activity is to contain control through deception, intimidation, fraud, or undue influence over the vulnerable adult or senior adult's money. Chapter 8 continues with Section 2903. 2903 is titled Financial Exploitation of a Vulnerable Adult or Senior Adult, Financial Institution Authority to Delay, Refuse, or Prevent Certain Activity, Expiration, Effect, Immunity. My goodness, it is all in the title. And while that is a lot of a title, when a financial institution or an employee of a financial institution reasonably believes or has information from the department or from law enforcement demonstrating that it has reason to believe that a financial exploitation of a vulnerable adult or senior adult may have occurred, may have been attempted, or is occurring, or is being attempted, the financial institution may, but is not required to notify law enforcement with a filing. Also, they have the ability to hold the transaction, delay or refusing a transaction, preventing withdrawals of funds, preventing transfer of funds, or preventing disbursement of the vulnerable adult or senior adult funds, including refusing to comply with instructions given to the financial institution by an agent or a person acting for the vulnerable adult. Insert power of attorney there. The duration expires at the sooner of 30 days, the time it takes to research and determine that the event is not financial exploitation, or by the termination of the court. The notification to third parties may occur. Parents, spouse, children, financial members, co-owners. They need not be signers to the account. Who can help in this type of situation? And as a financial institution, the statute provides immunity. With reasonable belief that complying with financial institutions with the financial instructions, such as paying a check, if that will facilitate the financial exploitation of a vulnerable adult or senior adult, the financial employee Employees, agents, officers, and directors are immune in delaying the payment of such check. They are immune from civil, criminal, or administrative liability taken to protect a potentially vulnerable adult or senior adult. This section, Nebraska Revised Statutes, Chapter 8, Article 9, has been on the books since 2020. Claire McHenry, Deputy Director of the Securities Bureau, will now walk us through an additional support that has been brought about this year with LB 297. Claire.
Thank you, Kelly. So the Nebraska Protection of Vulnerable Adults from Financial Exploitation Act was enacted on March 31st of 2021 and went into effect on August 28th. This bill built on the successes from the bill that Kelly just described. However, there are some differences between the two acts. This is due to the fact that the Securities bill is based on a model act developed by the North American Securities Administrators Association, otherwise known as NASA. The Model Act was drafted by NASA's Senior Issues and Diminished Capacity Committee, which is advised by industry representatives, federal security regulators, consumer advocates, gerontologists, and academics. Since 2016, the NASA Model Act has been enacted in 32 states, including Nebraska. A primary goal of this act is to preserve the ability of clients to make their own financial decisions while also giving financial professionals the tools to limit customer harm, and providing banking and finance and adult protective services the opportunity to investigate. The act defines terms, and similar to FI's act, it defines financial exploitation. It also includes the same definitions of senior adult and vulnerable adult as they are used in Nebraska's Adult Protective Services Act. We also define that this will apply to certain qualified persons, which include broker-dealers, investment advisors, agents, investment advisor representatives, as they're defined in the Securities Act of Nebraska, but it'll also apply to persons who are in a supervisory, compliance, or legal capacity for a broker-dealer investment advisor. This is to capture certain people who may not necessarily fall under a registration requirement, but still participate in the review of internal reviews and investigation of financial exploitation. The Act provides for a voluntary reporting of suspected financial exploitation by a qualified person to Banking and Finance or DHHS Adult Protective Services. The report must be made on a reasonable belief that the exploitation of a vulnerable or senior adult has occurred, has been attempted, or is occurring. No amount is too small. A reasonable belief of exploitation is all that is needed to make that report. And if you're in doubt, please call APS to have them make that determination. If it's not exploitation, they'll make a referral to appropriate resources as needed. I also encourage you to report every single time that you suspect exploitation of abuse has occurred, regardless of whether or not APS was able to get involved before or that the person has rejected assistance in the past. It may be that your next report is the one that gets them the help they need. The broker-dealer or investment advisor may also hold a transaction or disbursement from the account of the vulnerable adult or senior adult, or an account in which they are named as the beneficiary. The hold must be based on a reasonable belief after initiating an internal review that there is financial exploitation of the adult. If your firm is looking to take advantage of this hold authority, you should have some procedures in place about what that internal review is going to look like, including what information you're going to collect and who is going to collect it, and who will be conducting that review. If the firm does determine to implement a hold, they are required within 2 business days to provide written notification to the account holder. This is so that the account holder understands that the money that they are requesting will not actually be coming to them. Importantly, under the Act, the firm may not provide notification to a party that is reasonably suspected of actually perpetrating the financial exploitation. This is a safety issue. Many times a person perpetrating financial exploitation is a family member or someone close to the account holder who has already managed to gain access to that account. If someone is the victim of financial exploitation, there is a higher risk of them also being the victim of physical or sexual abuse. Notification to a potential abuser of that halt could lead to additional harm to that client. They are also required to notify both the Department of Banking and Finance and APS so that we can actually take action to investigate that hold and see whether or not exploitation has occurred before the hold expires. Additionally, while the firm is placing that hold, they need to continue their internal review. This is to make sure that the hold is still needed and also to assist the agencies with their investigation. The hold will expire at the end of 15 business days unless extended an additional 15 business days by either the request of banking and finance or adult protective services. So for our friends in APS, if you need additional time to investigate, please notify your firms that you need that time to investigate. The firm can also terminate the hold if they believe the transaction will not result in financial exploitation. This can be due to their own findings from their internal review. Or the hold can be terminated by a court order or from the agencies. If the hold needs to be extended further, the agencies, the firm, or another interested party can apply to the court to extend the hold, as well as seeking other protective relief. And this can include things like also seeking a conservatorship for the account holder. In addition to hold authority, any of the qualified persons can notify a third party if they reasonably believe that the client is the victim of financial exploitation. This is limited to people who the client has identified as someone who can receive information about that account. This is often called a trusted contact within the brokerage world and plays an important role within this act. It also includes any person who is permitted by law to receive notification. This would include people like guardians. It also includes any person where the firm and the client have agreed by contract to receive notifications. So this can expand this even further to include people like family members or other reasonable people associated to the client. This list is structured this way to allow the client to maintain as much control as possible over who is going to receive these notifications. Puts the client on notice about who will receive that, and also allow them the opportunity to remove certain people if they need to. This is the understanding that family relationships and dynamics can be complicated, and who we may think as being somebody who is reasonable to contact may not actually be appropriate in every circumstance. We often see this where a child is suffering from addiction or is actually otherwise estranged from the parent. And again, due to safety concerns, the qualified person is prohibited from contacting a third party that is suspected of the financial exploitation or other abuse of the adult. The Act also requires the firm to provide DHHS, APS, other APS agencies, or law enforcement with access to financial records relevant to the suspected financial exploitation. This includes records that are current and historical. This is to assist APS and law enforcement with their investigations and give them clear access to the records they need to provide financial exploitation. It also clarifies that these records are to remain non-public records. This is a Safe Harbor Act. No party is required to make a report, hold a transaction, or notify a third party. Qualified persons that do decide to take advantage of these provisions are granted qualified immunity from civil or administrative liability, so long as their actions are in compliance with the Act and they act in good faith and exercise reasonable care. You should be thinking about what you would do in these circumstances and have a plan of action before you are confronted with needing to make a hold or notify a third party. Firms I've seen have taken very different approaches about this in their internal review and establishing compliance procedures. Some have included it as a general compliance, as part of their general compliance program, and others have created dedicated teams that work specifically on financial exploitation issues. Whatever you do as a firm, it should fit within your firm's structure and make sense for your business processes and your firm culture. You also need to be thinking about other laws and regulations that may apply in these situations. For a broker-dealer, FINRA Rule 2165, the financial exploitation of specified adults, also allows for temporary holds. There is FINRA Rule 4512, customer account information, which requires the broker to make reasonable efforts to obtain the name and contact information of a trusted contact. Financial institutions and securities firms are also subject to a number of confidentiality requirements that prohibit sharing client information without client consent. This is included in Gramm-Leach-Bliley, SEC Regulation SP, and other state statutes. The Senior Safe Act sought to provide clarification that certain financial institutions and their employees would be immune from liability when they disclosed suspected financial exploitation of a senior to a regulatory or law enforcement agency, so long as they act in good faith and reasonable care and comply with the provisions of that act. And that act does include a training requirement for their employees. If you have additional questions about the Senior Safe Act, NASA, SEC, and FINRA have released a fact sheet that provides greater detail about that act. Financial institutions and broker-dealers may also be required to file a SAR in instances of financial exploitation. And when completing a SAR, it's important to include enough information in that narrative section so that agencies reviewing the report are able to understand what is happening and that they have sufficient grounds to actually start an investigation. This means including enough detail about what makes that person vulnerable and who they are, in addition to the details about the specific transaction. The other thing I'll say about SARs is that this should not be the first and last report you ever make about financial exploitation. Not all APS agencies actually have direct access to SARs, and Nebraska is one of those that does not have direct access to SARs. So if you're believing that APS may be receiving the information solely by receiving a SAR, they may not be. Making that additional step in contacting APS directly is critical. So now that we have these laws, how are they being implemented? We are conducting ongoing training for the industry on the issues of financial exploitation and reporting. This has actually been a priority for the department for quite some time. And we have actually held 7 trainings directly with firms and compliance organizations since 2017. In these trainings, we discuss things like red flags of financial exploitation and diminished capacity, the reporting process for APS, and what should be included in those types of reports. In most of these, we've actually been able to have someone from APS join us and have them be available to answer questions. We understand that while you may understand what we're doing, you may not understand what APS's processes are. And if your organization is interested in one of these outreach events or trainings, please feel free to contact me, and I'd be happy to set something up with you. Banking and Finance has also received department-wide training from APS about financial exploitation, red flags, and APS reporting. And we're currently developing internal referral procedures that include recommending to the firm to make a report directly to APS, collecting information from the firm, and also referring those reports to DHHS. But the real question is this working? And I would say yes. Even before implementation of either the FI or the securities bills, both banks and securities firms were reporting their concerns to us. This bill just provides them additional tools to something that they're already interested in helping out with. And since the securities laws went into effect at the end of August, we've received reports from securities firms that have included that they have used their hold and report authority and notification authority. And we are actively referring those reports over to APS. And just a few weeks ago, in October, we also issued a cease and desist order against a crypto mining investment company on a report we received from a broker. That broker was concerned that their client was looking to withdraw $250,000 from her brokerage account to help her daughter pay clearing fees to a crypto company. The daughter had already invested over $500,000 and was paying fees in order to access her investment, including borrowing money from her elderly mother to pay those fees. The broker raised its concerns with the daughter and the mother and made a report to us. We were able to determine that the daughter was the victim of a romance scam and was encouraged to invest money into an unregistered crypto mining investment. Fortunately, the daughter has accepted that this was not a legitimate investment and that she was the victim of a romance scam and halted any additional payments to that investment, and the mother did not withdraw $250,000. We issued a cease and desist order against the crypto company to stop violating the Securities Act, notified its internet service provider, which took down its website. I'm very pleased with the outcome of this particular report, and I hope that you can see how impactful it is when financial services, APS, and the Department of Banking and Finance work together to solve financial exploitation and to stop it. And with that, I'd be happy to take any questions. I see that we have one coming up.
Can you just repeat it as well?
Sure. Why are financial institutions in Nebraska not currently mandating reporters? If financial institutions are not liable, what is the harm for making reports? We try to maintain our consistency with the reporting requirements that were available under APS law, and at that level, they are also not required. Financial services are not mandated as reporters under APS law. We attempted to maintain that level of consistency. Any other questions? I see that we don't have any. On behalf of Kelly and myself, I would very much like to thank you for the opportunity to speak with you.